Good day, everybody. Good day, good day, good day. It's Atlanta Discuss. We're here again. This is our last episode for the year, and we have to make it special. Discuss issues that reverberate with the people of Nigeria once again. And our topic today is very straightforward. The obstacle to implementing the criminal justice system in Nigeria. We need to talk about it. Why it's so difficult to implement the law. The law is written. It's crystal clear, actually. You read it, it says the right things, but do we do it? No. Why it's not done, we don't know. But we have to discuss with people that know why these things are not working well. The ship of state, like many will agree with me, is now rudderless. People are dying every day just because they want to survive, just because they want to take rights. People are dying. That's unfortunate. Nigeria remains the largest concentration of Black people anywhere in the world. In America, 7 out of 10 Black doctors. I repeat, 7 out of 10 Black doctors are of Nigerian origin. You can just imagine, the most educated migrating bloc to North America. Some will even say to 2 continents in the world, or 3 with some statistics, are Nigeria. What is wrong with Nigeria? Why is it so hard to implement the law? Why is it that the vote of the people do not count? Those are issues that have been reverberating, that have been reoccurring. This country is debt-riddled, nothing seems to be working. But today we're talking about why the criminal justice system in Nigeria is not working well. And who else but the legal salamander himself, Jibril Samuel Okutepa SAN. My Lawrence Hill, welcome to Atlanta Discuss.
Thank you, Ade, my brother. How are you?
I'm fine. It's always good to see you, So,
I like your name because my elder brother, Chief Ade Akintola, gives me the title of Balogu of Ibadan. He said I'm his Balogu in the field of
law.
Yes, so Balogu is discussing with Balogu.
Interesting. Well, I'm from Abeokuta, so I know where Egbas are dynamic in so many, so many ways. All right, let's, like in our tradition, let's just go for the jugular. It's Christmas period, and I don't want to encroach into your holiday period. Now, institutionally, we're going to talk about different headings, while we're looking at institutional and structural challenges, legislative and policy framework, human rights and access to the justice system in itself, judicial and prosecutorial challenges also. There may be, if we have time, we'll look at community and societal factors. So what are the main institutional challenges, facing the criminal justice system in Nigeria, and how can we address it in the immediate and in the extended? Over to you, sir.
Well, I think the institutional challenges to criminal justice system in Nigeria are human beings, the Nigerians who have been given the responsibility to administer criminal justice in our country, that have failed the law that empower them to administer justice in our system. Nigeria is a wonderful country, and I love the country. There are many good men and women in that country, but the actions of infinitesimal number of people who have responsibility to give effect to law and order seems to have affected largely the good intentions of Parliament in drafting laws. Mark, I love my learned brother, the Honorable Attorney General of the Federation. No matter how good law is, if you give it to bad men and women to implement, they are likely to implement it badly. In other words, a good law in the hands of bad people produce bad results, while bad law in the hands of good people produce good results. So we seem to have, I don't know how to put it, we seem to have derailed in the purpose and intent of law in Nigeria. So much so now that when you come to the legal practice where I practice, we have become specialists in jurisdictional jurisprudence, rather than specialists in merit-based resolutions of issues. you then see that most matters are either terminated at infancy without looking at the merit of the matter. But since we are talking about criminal justice today, let me identify the institutions responsible for criminal justice administration in Nigeria. First, you have the law enforcement agencies, the police, the EFCC, the DSS, if you like, in collaboration with the Office of the Attorney General of either the states of the Federation, the prison service, and all other paramilitary institutions that have been given responsibility to enforce the laws of the land. Now, these institutions have the responsibility first to arrest those who have come in contact with the penal law of the land. They are the one to investigate. They are the one to gather evidence before it comes to the institution of courts where adjudication is to take place. And so when the matter is before the court, then you now have the judicial institutions that deals with administration of criminal justice in our land. Now, after the administration of criminal justice has been dispensed with, you have the institutions of prison yard, or the one we now call correctional centers in Nigeria. So these three key institutions are responsible for administration of criminal justice in Nigeria. Now, you discover that in most cases, the institution responsible for arrest, search, investigations, and prosecution, populated by no less a person than Nigerian of full blood of both parents, have unwittingly allowed themselves to be compromised, so much so that they are more powerful against the small fishes when it comes to the exercise of their power. In other words, if you and I have the misfortune to come in contact with these institutions, they are likely to be more brutal, more forceful, I don't want to use the word, but it appears that more wicked in the handling of the matter than when it comes to the one I call the big thieves. So the big thieves have unwittingly, of the security agencies unwittingly, in some cases, have allowed themselves to be compromised by the big thieves. And so the big criminals or alleged criminals who are pilfering with our natural resources have found way and means of pocketing these security agencies. So much so now that these security agencies have become instruments of perversion and persecution of the downtrodden, the poor masses, and indeed, they become also agents of political witch hunt. So much so that a man or a woman who decides to make a critical assessment and critique of those in power or those close to power or those who are feared by the power that be, because the power that be fear other power too. These are people that the security agencies cannot go. I call those ones, thou shalt not touch them. And you know them, you see them by their fruits, by their movement, by the way and manner they acquire property, the way and manner they drive around. The police officers, the security agencies are just subservients. They are just their servants. And so even when the policeman or woman or security agencies see these people doing what the law had prohibited, they have completely refused to arrest them, to investigate them, and prosecute them. And even when, peradventure, you have police officers or policemen and women, security agencies that are bold enough to arrest them, these bigger thieves have connections. They have founded leadership to power. They have founded political parties to power. So I call these other types of thieves too as money bags. So apart from those that are not touched, they are also money bags. So their money speaketh for them. And so you will now see that in our society, there are allegations that these are people also who sponsor miscreants to cause mayhem, cause untold hardship, and even at times trying to bring government that is not cooperating with them to bring the government down. So, in other words, they infuse in the security agencies what I call investigative timidity or prosecutorial timidity, or they buy them off, and real evidence that needs to be used to nail these people are destroyed. And so sometimes when they now manage to bring them before the adjudicating authority, which is the court, you are likely to see that there is no watertight evidence. Mark you, Nigeria is about the only country I know that arrest before investigation. In other climes, you are marked, you are monitored, you are waylaid, your activities is being underground over the years. Evidence are gathered. You gathered evidence that are watertight. By the time the security agencies come to meet you, they have irrefutable evidence that you cannot say no. So when you see Nigeria behaving very well in advanced country, it is because in those countries, there's what I call the terrorism of law, the nationalistic application of law by the security agencies, those in power. There is what I refer to as a complete code of conduct. And there is a boundary beyond which you cannot go in this country. For instance, if you are, as you are in America there, you cannot just park your car on the road and start defecating. You will be arrested. The same thing with the United States, United Kingdom. No matter how a child is pressed in this country, you cannot say, "Mommy, Daddy, please, I want to wee," and you stop on the road. You are picked. So those are countries that there are law enforcement agencies, the people in government know what is right, what the government needs to do to avoid health pollution and all manner of health hazards. And so there is a boundary you cannot cross when you are pressed. And so they now have conveniences in places. In the budget of this country, therefore, money is not humongously allocated to the few infinitesimal number like we have in Nigeria. When you look at the budget, a 2025 budget presented by Mr. President, you see the amount of money voted for health, less than 50 billion. The amount of money budgeted for education, less than 50 billion. And that is education and health for over 200 million Nigerians. But when you look at the amount budgeted for the infinitesimal number of 440 something people in the parliament, you are seeing a humongous sum of 125 million or thereabout. So then you ask yourself question, why do government have to budget more for few Nigerians in privileged position than to budget more to take care of the social needs of Nigerian people? So in other words, therefore, the problems that is largely responsible for the ineffectiveness and inefficiency of our criminal justice system is the human beings, the Nigerians who have the responsibility to be in this place. I'm not saying that all Nigerians are bad, but those other good ones in the system are overshadowed by the character, the conduct, and attitudes of the few who are either ahead or where those whom the few good ones are subordinate to. And so they overrule them, and it is the decision of those who implement that matters. And so today, you are likely to have these are responsible for our criminal justice obstacle. Then when you come to court, you now have so many challenges in the court because Nigeria operates what we call acquisitorial system, not inquisitorial system. In other words, if you are arrested, say you have stolen 200 and something billion or trillion, the burden is on the state to prove the allegation beyond reasonable doubt. The burden is not on the accused person to prove the falsity or otherwise of the allegation. And so the Nigerian Constitution said, if anybody is arrested, he has the right to keep silence. That's why when I look at the criminal something instituted against Dele Farotimi, and when people come to say that he must come to court to justify the content of his book in a criminal trial, I do not think so. That represents the principles of law we operate today. And so the criminal justice system of Nigeria is acquisitorial. The burden is on the state or whoever alleges in a criminal trial to prove, not just to prove on a balance of probability, but to prove beyond reasonable doubt. Where there is doubt, therefore, the doubt is resolved in favor of the accused person. So, in most cases, therefore, poor investigation, poor prosecution, lack of evidence, and mark you, if there is no evidence in support of a charge, no matter how you think that the person is guilty of an offense, he will be discharged and acquitted by the court. And so sometimes people blame the court as being responsible for the failure of criminal justice system. I do not agree. It's not in all cases. There are some cases that the court would have wished that the criminal is convicted, but to use the words of one of the eminent jurists in Nigeria, their hands are always tied. And they cannot convict on the basis of scanty evidence. I remember sometimes in 1995, I had a client, and I have a client who was accused of robbery. And so when we went into trial, at the end of the day, the man looks seriously like a criminal, but the evidence could not prove the allegation. And so when he was discharged, I remember the learned trial judge looked at him and said, "My friend, look, just look at me. Just look at me. I am discharging you because the law says I should discharge you, but I know you are a criminal. Go and repent." Not too long thereafter, the young man was rearrested, and the rest is history. He was no longer brought back to court, and he is gone. So sometimes it is when you see some extrajudicial extermination of lives, it could be by people within the system who believe that the judiciary should have been more sympathetic to them than allowing the criminal to go. So the court in adjudication in criminal trial is hamstrung by paucity of evidence or lack of it, or poor investigation in the criminal trial. But like I said in the beginning, the court also cannot escape blame in some instances. For instance, when it comes to a bail, Why should the court insist, for instance, on written application before it can listen to application for bail? In the beginning, it was not so. In the notorious case of Ono Bepa against the state that everybody quoted, I remember when I was reading that report, the accused person was brought to court, and the learned attorney for him then, who ended up in the Supreme Court and now retired, asked the man to go to the witness box. And he was sworn on oath and said, if you are granted bail, will you run? He said, I will not run. Will you tamper with investigation? He said, I will not tamper with investigation. Will you abscond? He said, he will not abscond. He said, I will present myself at all material time for my trial. Oath was administered to him. He entered the witness box. He asked him to come down. The prosecutor did not cross-examine him. And then the prosecutor said he's opposing bail. So the learned magistrate did not see his way clearly. And then until the matter got to the higher court, and my Lord Honorable Justice Idoko, J as he then was, who later became Chief Judge of Benue, and now of blessed memory, made a beautiful pronouncement in that Ono Bepa against the state, where he said in a non-capital offense, bail is a basic fundamental right. And my Lord Justice A.J. Eko, JSC retired, was the defense counsel in that case in the early 80s. So the point I'm making is that it's not in all cases that prosecution should insist, or the court, because the court these days had made it a duty that you must bring a written application before an accused person can be entitled to bail. So part of the obstacles also to effective criminal justice administration, therefore, is the attitude of some of the judicial officers who are not following what the law says. Because under the Nigerian Constitution, there is a presumption, and that presumption is in chapter 4. And this chapter 4 of the Constitution is the fundamental rights chapter of the Constitution, that an accused person is presumed innocent until the guilt is proved in the court of law. But the attitude of some of our judex appears to be rooted in inquisitorial adjudication rather than acquisitorial adjudication. And so most judex seem to presume that an accused person who had been brought to court is already guilty. And so sending a man or a woman to prison when his guilt has not been decided is, for me, one of the greatest disservice we are doing to our criminal justice administration. It leads to prison congestion, because if you go to our prison, it's like a ghetto. You see that a room that is meant for just 2 persons, you may have to see about 10, 20 persons. And so when you go to prison, the people sent to prison are infused with some sort of psychological timidity, and they fidget. You see them, when they call them to come, they are treated less human. And that is contrary to the spirit of our Constitution, that requires that no man or woman should be subjected to degrading or indignity in life. And so then when you come to, in 2015, for instance, after all said and done, we enacted what we call Administration of Criminal Justice Act. This Administration of Criminal Justice Act applies in all federal courts. But today, the provisions of that law are being obeyed in breach by virtually everyone. For instance, there is a provisions in that law that an adjournment can, when a trial is to begin, adjournment shall be from day to day, and no adjournment shall be given that is more than 14 days. But you see some judicial officers adjourning criminal trial for 3 months, contrary to the spirit of this Administration of Criminal Justice Act. And the people are in prison custody. Currently, as I speak with you, there is a case, I won't name, and I must commend the Honorable the Attorney General of the Federation, because he was a good practitioner before he was appointed the Attorney General of the Federation. And mark you, you need a strong-willed Attorney General who can look at his appointer or whoever and say, no, this cannot be done. I must also commend the Director of Public Prosecution of the Federation. There is a case that a very powerful individual had connived with policemen, charged two brothers to court. They have been in detention since March 2024. At the end of the day, the Office of the Attorney General, through the Director of Public Prosecution in the Department of the Attorney General, after having studied the case file, discovered that there was no case against these two brothers who have been taken as human collateral by the most powerful society and file a nolle prosequi. That is, I've taken over and discontinued the case. And there, as I speak with you, today being the 21st of December, as I speak with you, the learned trial judge has refused to discharge the persons.
Oh, wow.
I refused to sit.
Oh, wow.
We went to Court of Appeal. Court of Appeal saw the nolle, but refused to discharge these people on the ground of jurisdiction.
Oh, wow.
I do not understand how. That's why I say from the beginning that the challenge and obstacles to our effective criminal justice administration in Nigeria are the human beings involved. And I do not know how some judicial officers sleep. Seeing your fellow human being in prison for no offense, the chief law officer has written that I've seen no offense, yet you kept them in prison custody. I do not see why a magistrate will remind a person who walked to court in prison custody and put very difficult bail condition, even the condition that is beyond the civil jurisdiction of that magistrate. So when you look at it, therefore, is that my conclusion is that Nigeria prefers to operate the rule of law, but we have done everything and virtually almost everything in opposite direction of the rule of law. Because where the rule of law holds sway, both the big, the small, the mighty, the mightiest are subject and equal before the law. But in our society, with profound respect, the mighty have the law in their pockets. They are above the law. They manipulate the law. They abuse the law in aid of a right, which invariably, when subject to the truth, they may not even have. So
let me interject you there for a minute. I mean, you've done fantastic justice to it, but let me ask a follow-up to the question. I've spoken with legal luminaries, some some mostly professors like Professor Odinka. He said that he thinks one of the problems also is that a lot of judges, lawyers, they're handing over to their children. And he gave some examples, like in the NGI, Nigeria Judicial Institution, that is filled up with children of lawyers and judges. And then it's so many judges now are children of maybe former days, all from the legal profession. Now, he's saying that it's not as if it's against a judge child or a senior lawyer's child taking over or getting a position, but it's not based on merit. So I'm putting this question to you: that is that part of the problem we're having, that a generational handover, making it like a rite of passage? If my father is a son or a former judge, I become a judge and all that. So does that also affect the effective operation of criminal justice? Does it also make it, I mean, the lawlessness you're talking about, can we call that part of the problem?
Indeed, the fundamental problem of what we are seeing today is the recruitment process. whether that of a wife of a politician, the son of a politician, the son of a serving judge. The recruitment processes of our judicial officers as of today, I have written on it, is faulty. Look at it very well and go back to memory lane. When we have fantastic judicial officers, how much was their salary? Nothing. The office of a judge is an office of honor, is an office of integrity, is an office with prestige, because you are just a representative of God on the planet Earth. But it is not enough for you, for instance, to meet the basic qualifications of appointment to the bench. No, in those days, before you can be considered and approached to become a judge of the High Court, for instance, their lordships before whom you have appeared must have looked at your comportment as a lawyer, your practice, which must be rooted in the light, not in darkness, your appearance, the way and manner you conduct your cases before them, and then how matured you are. You know, a judicial officer is not a talkative, and he must possess the element of maturity and strength of character. The one that can say no, even with the dagger on his head, if what you are asking him to do is contrary to law. Because every judicial officer subscribes to oath of office and oath of allegiance. The oath of office of a judicial officer is to the effect that I take this oath to do justice to all manner of persons without fear or favor, affection or ill will. But today, some of our judicial officers did not meet the basic character requirements. Then they are given the responsibility. Some even have intellectual deficiencies in understanding the deep jurisprudence and logic. And so as a judge, not only must you know the letters of the law, you must also know the spirit behind the law. And so when a judicial officer is bereft of idea of the spirit behind the law or the letters of the law, such a judge is unfit to sit on adjudication. Balogu, my dear, when you go to a fine jurisprudence in our code of conduct and code of ethics, a judicial officer ought not to have foreknowledge of the facts of the case before him. But how many of our judicial officers can we, in all honesty, say of today that they are not in the know of the facts, or that even if they are not in the know of the facts, that in their heart of hearts, they don't know one or two persons connected with the litigation? So you now see that apart from what Professor Odinkalu had identified, there are much deeper issues. And that issues is the issues of the character of judicial officers we recruit to the bench. Now, a judicial officer must not be gluttonous in property acquisition, because he is not like one of those political officers who acquired unexplained wealth. So when judicial officers, therefore, some of the judicial officers, therefore, began to emulate those who pilfered with our natural resources, quality of adjudication in such courts becomes permanently eroded and dwindled. So I agreed, because if the foundation be destroyed, what can the righteous do? The foundation of a sound judicial system is rooted in the recruitment process, and then it's also rooted in the independence of the judiciary.
Judiciary. Wow.
Now, how independent can we say our judicial system is? Now, you may recall my tweet or write-up on X when those children were brought to court.
Yeah, I remember.
Children that were arrested, brought to court. Now, the bail condition was as no bail, because I do not see where those children will get 10 million to shorty those who are landed property in Abuja. At the material time that the children were brought to court, His Lordship diary was filled to January 2025.
Wow.
But suddenly, when there was outcry, the judge suddenly had diary space in his diary, and then they brought the case forward. The children were discharged. So I asked myself the question: what was wrong with the diary at the time the matter was adjourned to 2025? How come that it is when the president and commander-in-chief had made an order that those children be discharged, that the diary became suddenly vacant in less than 3 days or 4 days? So that speaks volume as far as I'm concerned. The judiciary must be independent.
Absolutely.
And if a judicial system is not independent, I do not want to go to other arm outside of our criminal something. But when you look at our electoral jurisprudence as of today, there is something that suggests to me that the judicial system is strangulated or has allowed itself to be strangulated.
Fantastic. So, I mean, you know, I was saying we should look at legislative and policy framework. You've covered that also to a large extent. So let's go to human rights and access to justice, you know, and I mean, we can't talk about this without looking at the Dele Farotimi case, you know. So I was going to ask you, how do human rights violations such as arbitrary detention and torture, you know, undermine the credibility of the criminal justice system? So, I mean, while you're answering that, I want us to look at the Dele Farotimi's case, you know, the issue of criminal defamation. It's been widely said that it's not even in the statutes of Lagos and Ekiti. So, I mean, we can start with the Dele Farotimi's case now. What actually is the government doing wrong in this instance? Because I was watching Professor Odinkalu, I think yesterday also, when he said that the process itself is faulty, that the Dele's book has been, whatever I wrote in the book, has even been vindicated by the process that they are using against him. So, talking about human rights and access to justice, so how do human rights violations such as arbitrary arrest and detention, torture, undermine the criminal justice system? Let's use Dele Farotimi as a focal point. Go ahead, sir.
I do not want to use Dele Farotimi
because he's in court.
Because it's in court.
Yeah.
But I would like us to focus on what I call what is the remedy in Nigeria for judicial lawlessness.
Okay, go ahead.
Because when you see judicial lawlessness, you will know. When a judge purports to do what he has no right to do, that, in my estimation, is a judicial lawlessness. What do you do with a lawless judge? What is the remedy for those who have been lawlessly dealt with by judicial officers? I gave you one example before, where under our law, once there is a nolle prosequi entered by the office of the Attorney General, either of the federal or of the state, the matter is automatically ordered to be discontinued. And the moment the defendant is kept in custody at the behest of the judiciary, what remedy does the person have? The only remedy, as I see it, is for the person to go and petition the National Judicial Council. And in most cases, how does the victim of this judicial lawlessness get remedies from National Judicial Council? Dismissing a judge does not compensate the victim. Maybe pacification, but what about the days it was incarceration unjustly? How much will the state pay? I know of a case from one of these European country where a judge exercised jurisdiction he did not have. The state was sued. And I have said in my write-up that time has come when we must remove, under certain circumstances, immunity of judicial officers from being sued. Because both lawyers and judges have immunity in what they do in court. But in my view, if as a lawyer, you file a reckless process that leads to the infringement of fundamental rights of a human being, of another citizen, I see nothing wrong for that lawyer to be indemnified in damages if sued. In the same way, when a judge knowingly and intentionally allow himself or herself to be used as instrument of persecution rather than instrument of justice, and coming to, because is it not that the Constitution set up the courts as avenue for remedy? But where you run to court or you are brought to court and the court acts in a manner inconsistent with your liberty, which the court ought to jealously guide, then in a proven case of willful violation or refusal to do what you are supposed to do, such a judge should also be sued. It has been my submission, because the level of judicial lawlessness in Nigeria, by the employment of frivolous processes that has no backing of the law, is assuming an alarming proportion. And until we all agree to deal with it, we are likely to get back to what Obrusian call the state of nature, where the mighty become right, life in such a society becomes brutish and nasty, and there will be no place for industry, just like we have today. So my view, therefore, is that the fundamental rights of Nigeria in the kind of situation we find ourselves today, particularly the less privileged and those who use the social media to hold government and those related to government people accountable, are facing persecution rather than prosecution. And it is unconstitutional to use criminal justice system to persecute rather than prosecute. And I know of series of cases that the Office of the Honorable Attorney General of the Federation had interfered. But that is if you have
access.
No, not access. You don't need to have access to the Attorney General before the Attorney General, a chief law officer, can do his work.
Okay.
Now, there is what is called case file. And no case, criminal case, will be filed without prima facie evidence in the case file disclosing the offense. And that offense must be rooted in law of the state, because Section 36, subsection 12 of the Nigerian Constitution says nothing is an offense except the penalty for doing so is prescribed in the written law. Therefore, the fact that you are aggrieved by the conduct of Mr. Okutepa, that what Mr. Okutepa has done, you are not happy about it, does not give you license to arrest me and charge me for an offense that does not exist. Because that itself is a violation of my fundamental right that I must only have my liberty curtailed upon reasonable suspicion of a crime. So where there is no crime, therefore, and no crime has been committed, using a criminal justice procedure to contain the liberty of a person is a direct violation of the fundamental rights of the citizen. So my view, therefore, is that I started from the beginning by informing you that the problem with our criminal justice and the obstacles for the effective and efficiency of it are the human elements. You know, it's only in our country that a day will come and say, do you know who I am? Don't you know I am based in Atlanta, Georgia, and I'm the mayor of that place? And then every other human being is less human. Perhaps we should begin to ask questions. Why do we behave this way? And the answer is very simple. Whoever has a little resources, even if it's unexplained, becomes king and is so powerful. So my answer to your question, therefore, is that yes, there are instances, provable instances, where people have used the criminal justice system unjustly to incarcerate citizens. And I was making reference to the Office of the Attorney General of the Federation when he said there was a case that lasted for almost 5 years. Somebody forged a signature of a director of a company, took his contract, was using it, and collected the money. The person made a report to the police. Instead of arresting the people and prosecuting them properly, the person turned around to use the instrumentality of the security agencies to charge the victim of the fraud to court. He was in court, he suffered, he's still suffering, and then until I got involved, all legal advice had come on series of occasions before the Honorable Attorney General came into office. The legal advice comes, no case, withdraw the case. Another one will come, continue the case, withdraw the case, continue the case. The man suffered in court for 5 years plus, until the current Attorney General reviewed the entirety and ordered that the matter be discontinued. Even the judge, with police signals and everything that were before him, he still closed his eye to it and said the person should enter defense. So if there is no case, why should you force me to enter defense? So in other words, until we have people who have not sold their conscience and have respect for their fellow human being, there must be humanity in those who operate our criminal justice administration. If there is no humanity and love of your fellow human being, and you can close your eye and lock somebody in a dungeon simply because you are angry, then we are not respecting our laws. Because in a society where the rule of law holds sway, individual anger, individual power is subsumed and reduced and brought under the rule of law, because nobody in such society is above the law. So in other words, for me, if Nigeria must continue to profess and claim to be operating under the rule of law, we need to review our attitude Because the problem of Nigeria is not about law.
Yeah,
it's human.
Human, I agree.
It's not law. There are laws that prohibit unjust application of the law against human beings.
Okay.
But we are unjustly applying the law, and then we are divided, supporting. Look, a man or a woman may have committed an offense, but the law set out the procedure to deal with that person. And so you cannot resort to arbitrary use of procedure and be claiming that you are fighting for a right. Fighting for a right in an unjust procedure is itself unjust.
Interesting. Let me read something you tweeted some time ago. You said, on the 13th of December 2019, I wrote that I really weep for us, lawyers in Nigeria. Some lawyers are just agents and conduits through which justice is being perverted in Nigeria. Unfortunately, we have no self-enforced regulation to deal with them. In saner countries where the rule of law and rule of professional conduct are followed and enforced, any lawyer who accepted brief to delay proceedings and scuttle the hearings of cases in court loses license to practice law. Automatically, we said, there's no ceremony about it. The bar is now up and doing. The bar is now up and doing to ensure that rules of professional conduct and the etiquette of the profession are respected and obeyed, but not in Nigeria. In Nigeria, we play politics and trivialize everything, including the most serious things that affect the lives and liberties of the subject and serious constitutional question. So, I mean, I understand why you said this and all that, but why is this so hard for the legal profession? I agree it's human error. I agree we have good, we have bad and all that, but why is it so hard, for the bar to do the MBA and all that? Because according to what you said here now, that might not even be, we have no self-enforced regulation to deal with them. That's really why I asked it. Why is that so? Why don't we have there should be regulation? Because
no, there is
go ahead.
There is regulation, but it's not self-enforcing.
Oh, okay. Nobody's implementing it. Yeah.
No, under our laws, including discipline of judges and lawyers, somebody has to complain. Oh, and that's where we miss it. Now, if Ade is a lawyer, Ade is from my village, and Okutepa is a lawyer, Okutepa is from Ade's village, Ade has seen that Okutepa is doing what is not correct in law and ought not to be a lawyer. Tendency is for my traditional rulers, my community, the people that have benefited from my misconduct, and I'm using this myself as an example to drive home the point, has to write a petition. And we have made it so much in our rules that the petition must take a certain pattern with certain verifying affidavits. And if that pattern is not followed, Ade, no matter how grievous the allegation is, it will be thrown away by the disciplinary body. For instance, I was the chief prosecutor for the Nigerian Bar Association at the Legal Practitioner Disciplinary Committee of the Body of Benchers for 5.5 years. Oh, wow. And having prosecuted with a commitment with the late Emmanuel Aguma SAN and my other colleagues, we cleared some of the backlog petitions against some lawyers. Some lawyers have their names struck off the roll. Now, under our laws, once a lawyer's name is struck off, ordered to be struck off the roll, he has a right of appeal within 28 days to the Supreme Court. And your guess is as good as mine. An appeal that was filed, a case that has started on the 12th of January, 2001, ended up in the Supreme Court on the 12th of January, 2024. 23 years in the court. So, an appeal against a disciplinary process that is filed in 2024 may be in the Supreme Court for the next 10 years. And under our laws, if a lawyer whose name has been ordered to be struck off the roll have exercised the right of appeal to the Supreme Court, the law says he can continue to practice. So this brings me, apart from human element, and it is also human element, is that we must agree as a profession to have boundary beyond which we cannot cross. And whoever crosses that boundary is automatically dealt with. Now, when we lay a boundary beyond which we cannot cross, we must not create a window for crossing of that boundary. For instance, why should we put in our laws made by our parliament that a lawyer who has been ordered to have his name struck off the roll can still continue to practice until his appeal is determined? I think it's the other way around, that a lawyer whose name is struck off the order to be struck off the roll should have his name automatically struck off the roll, and the burden should be on him to apply why he should be given a temporary license to continue to practice. But so when I was prosecuting them, I'm coming to a serious matter. Yes. There was a lawyer, because our rules prohibit a lawyer from engaging in extrajudicial communication with a judicial officer. If he must discuss with the judicial officer handling the matter, he must go there with his colleague on the other side. And we have evidence of this, and the matter I prosecuted, and the man was ordered that his name be struck off the roll. Now he appealed to the Supreme Court, and the argument in the Supreme Court was simply this, that the panel of the LPDC that was hearing the matter keep changing. Today are they seats, tomorrow are they will not sit, another person will sit according to the Supreme Court decision, and that the inconsistency in the quorum of the panel goes to the root of adjudication, and the entire proceeding was declared null and void, and the person was set off the hook. The merit of the professional issues was not touched. So when you then come to this one, this is the kind that I, in my view, think that had not done justice to professional discipline in our profession. Because after that, all manner of objections to procedural steps were taken, because once there is evidence of professional misconduct, I do not think with profound respect that the inconsistency in the change of panel members can affect the case. But the question would be, was he in communication with the person or was he not? If it is, what did the law say? We would have dealt with it, but there was a setback there. So if you go to NJC too, it's the same thing, the procedure. So that's why I said that the procedural steps of enforcing discipline in the bar is not self-enforcing. Unlike in the UK, where they have independent solicitors prosecuting authorities that monitors and deal with the question, it's not so in our own society in Nigeria. So we need to have a self-enforcing and self-regulating. But then when you do that again, you begin to see the application of human elements and even on just operation of the system to the prejudice of those who may be vocal.
Okay, quick one, sir. Quick one. This is going to be my last question to you, because I know you have a busy schedule. It's a two-in-one, actually, because it's clear it's looking like it's failure of leadership, because that's the way I say it's failure of leadership. If you have to be intentional about all these things, and all that. So the first one would be, what role can the civil society, civil society organization, that's one, community groups and international partners play in supporting the implementation of the criminal justice system? I didn't say government now. I didn't say
they are doing it now.
They're
For
doing it. Okay.
for instance, the civil society organization are taking it upon themselves to cry out that we are not getting justice in our courts.
Okay.
They are putting the judiciary on the toe. Forget about the bone face that we don't care about what the public say. You cannot say you don't care about what the public are saying when the end user of the product of the court are the public. So, and in any case,
and they are not happy.
The public are not happy. In any case, we have what we call reasonable man test in law. So it's not reasonable lawyer's test, it's reasonable man test. What will the man on the street of London say in the judgment that has been delivered? That's where we say that justice is rooted in confidence. If the right member of the society goes away thinking that justice has been murdered, then justice is not done, because justice must not only be done, but must be seen to have been done. So the civil society should continue to put pressure. If somebody is arrested unjustly, like the NSAS, like so many other cases that we see, like you see people are living in affluence and they are putting peanuts for what matters to the people, the civil society, and I thank God that social media had come into being. Everybody should be in a position to speak out against unjust system. The community, unfortunately, today, the community are almost imperiled a little. Because if you go to any village today from where you are and start flying dollars and throw it away, you will be surprised that old men and women, young boys and young girls will come to the road to start picking this money without asking about the source of your income. And that's why you see that unnecessary rituals are being done for people to have. So community people must begin to de-emphasize about worshiping of wealth and money. It is not so in those days. I'm happy in the beginning you say you come from Abeokuta. In those days, and I come from the Igala land, in those days, we have the do's and don'ts. There are things you must not touch. Absolutely. There are certain gifts you must not take. Your families will discipline you if you come home with properties that you cannot explain who gave it to you. But today, you will see that some parents are nudging and urging their children to go and make money at all costs. So we must drop the worshiping of money. So the community, in my estimation, is being reduced to the kind of society that we now have. You see that, like, we don't have time to talk. In the places in Nigeria, when they are now giving handouts to people, people are dying from a stampede of the rice.
I mean, it's so unfortunate.
You see them, people are struggling to take for a bag of rice, even a loaf of bread.
And it's happening in 3 or 4 locations consecutively.
Locations in Nigeria. And that is Nigeria where if you dig your room and plant yam, it can germinate.
Absolutely.
So we have reduced the human element in the society to so ridiculous level now that all that everybody thinks about is I am entitled. It's my money. So they don't ask and they want to take. Otherwise, I consider it an insult for people to be gathered, come and take rice. When they talk about palliative in government, even the people that are supposed to distribute these palliatives, some of them are thieves. They take the palliative, hoard it, and it's rotting somewhere there. So again, that brings us to the level of human being involved. What has gone wrong with our moral fabric? What is our value system? Do we have value in our society?
Before you land, I like where you're going. Now, I want to chip in. Wherein lies our spiritual leaders in all this? Considering that we are very religious, Islamically, Christian-wise, we're If you open a Nigerian TV station, there's always revival, the church service. We have, there's churches that have 40,
Are
30,000 parishes. Where are they? What role are they playing in the ensuing million? I'm listening, my Alex.
Our spiritual leader better than the people they are leading? There are good ones, but I think that the majority have commercialized the spiritual callings on their lives. So, even in ecclesiastical world, the ills of Nigerian society can be found there, and it's been justified. There is no longer the morality that is expected from our religious leader. Why did you get fake bishop, fake this one, fake that one during election? Because when Karl Marx said that the religion is the opium of the society, I think he was right. And so, with profound respect, and like I wrote today, that in Nigeria, we fight for God, but too far from God. We no longer keep to the tenets of the scriptures or the Quran. People believe, look, some people preach in the congregation or in the gathering that ought not to preach. How many of our religious leaders are like Elijah in the Bible that can look at Ahab direct to the face and talk to Jezebel like Elijah did? They cannot, because he who comes to equity must be clean.
A quick interjection, sir. Respectfully, there's a leadership failure. The judiciary is not doing what they're supposed to do. Our religious leaders are non-existent. And the traditional institution too is not faring better.
There is no traditional, with profound respect.
Yeah.
The traditional institutions in the manner at the time of Aderemi,
about this
and the Ame Oboni of this world, Taibo Ijomis of this world from in my kingdom, the
Obadiwalas of
Egbaland, the Obalipede, all those Obas, it's gone. The traditional institutions appear to have been politicized.
So even the quality of traditional rural will have rise.
No, let us go back to basics. For us to have effective and efficient traditional institution, government should have nothing to do with them. As long as you begin to appoint traditional rulers at the instance and at the instance of the power that be, these governors and leaders will appoint political stooges as traditional rulers. And I see most of our traditional rulers, with profound respect, as political appointees. I call them political rulers, not traditional rulers, because the traditional rulers will have nothing to do with some of the shenanigans going on. But if you go there, they have been infused with timidity. It is, you see, I love the late Basharu of Abiola. He said the hands of the giver is always on top. So when you are not qualified, you begged to be made. The beggar will always go cap in hand to the person who is begged. If there is beggar begging, so I don't know how to put it in this way. So I think it's a whole lot of things. In other words, to conclude this matter, we need to go back to basics. What was the Nigerian situation?
How do we go back to the basics? Do we need a sovereign national conference? Do we need a leader? Do we need to have proper elections? Who is going to lead this recalibration? How do we do it?
Look, do you know why? Do you know how we'll go back?
Yes, sir. I'm all ears.
I am praying that our suffering continue. When we come to our senses, then we will now sit down. We are behaving like the prodigal sons. We have taken all that our father had, and we are spending them on harlot and prostitution. When the entire resources appears to have escaped our hands, then you are eating with pigs and all manner of things from the dustbin. You then come back to yours. Look, before.
Fantastic analogy.
Before, you hardly can see people talking, but today people are talking. Do you think that those who have their loved one killed in this stampede will forgive those who caused the hunger in the land?
No, absolutely not.
Good. So when I heard somebody saying that offering a curse on people in power is a criminal offense, I weep for this country.
Honestly, it's...
So for me, let us continue to engage. Let us continue to discuss. The few that are good to continue to be good. None of us will go back to defile ourselves with the rotten things in the society. One day, who knows, when we have a leader who loves the country, who loves you and I, that leader may now set a direction, the trajectories we should go to arrive at the promised land. And that leader may come through the most unjust election, but he may decide to put the system in place. But as of today, let me conclude it this way. Nigerians are not all that bad. We lack leadership that is focused with direction for the good of the land. We lack leaders that will want the vast majority of the vast Nigerians to enjoy life. So until we have leaders who are not interested in the commonwealth of our people, but interested in the welfare of the Nigerian people and development of Nigerian states, we will still continue to suffer the way we are suffering. Our suffering, for me, has just started.
Fantastic. Thank you, Jibril Okutepa SAN, the legal salamander. No holds bear, straight to the point, you know. These things are self-inflicted. Honestly, all our problems are self-inflicted. They are human.
That is true.
Yeah, they are self-inflicted. If you're a teacher and you are giving marks to a child whose parents give you money, you are part of the problem.
Yes.
If you're a policeman and you are selling bullets to armed robbers, you are part of the problem, you know?
That is true.
There's a trickle-down effect. I understand the fact that there are people at the top that are encouraging this. The clerk in court is as guilty as the judge, the prosecuting attorney, and everybody, you know, we're all guilty one way or the other, you know, and that's why sometimes I just come and say maybe we're inherently dishonest, because culture itself, we eat strategy for breakfast. Is this our culture? It's looking like it, but we cannot go like this forever. I know, and I'm very sure something will give eventually. When it will, how it will, I don't know. So this is our last edition for the year. Thank you, my SAN Okutepa. Fantastic. Enjoy your vacation. And I'll see you in 2025. And I will hope to come back and be better. We wish Nigeria, we wish United States, we wish everybody all over the world, you know, a prosperous 2025. It's the world is going to be more interesting. The signs are there. How will the Ukraine war end? You know, a new president in America, new dynamics. Nigeria is going to get more interesting. We've seen the budget. It doesn't look like, you know, anything has changed, you know, because of the devaluation and all that. So it's going to be an interesting 2025. And we at Atlanta Discuss, we promise we'll be there. And we now have a newspaper. I'm sure some of you have seen it, Atlantic Digest. Just go there, atlanticdigest.com. We're there. So thank you all. Thank you, Mr. Okutepa. Thank you to all the people in the 7 continents of the world. God bless you all. It's a wrap. Bye.
Thank you.